Irish nationality law is contained in the provisions of the Irish Nationality and Citizenship Acts Chapter 1956–2004 and in the relevant provisions of the Irish Constitution. A person may be an Irish citizen through birth, descent, marriage to an Irish citizen or through naturalization. The law grants citizenship to individuals born in Northern Ireland under the same conditions as those born in the Republic of Ireland. Acquisition of citizenship. At birth, a person born on the island of Ireland on or after the 1st of January 2005 is automatically an Irish citizen if he or she is not entitled to the citizenship of any other country, or is entitled to be an Irish citizen if at least one of his or her parents is an Irish citizen, a British citizen, a resident of the island of Ireland who is entitled to reside in either the Republic or in Northern Ireland without any time limit on that residence, or a legal resident of the island of Ireland for 3 out of the 4 years preceding the child's birth. A person who is entitled to become an Irish citizen becomes an Irish citizen if he or she does any act that only Irish citizens are entitled to do, or any act that only Irish citizens are entitled to do is done on his or her behalf by a person entitled to do so. Dual citizenship is permitted under Irish nationality law. Ireland previously had a much less diluted application of jus soli which still applies to anyone born on or before the 31st of December 2004. Although passed in 2001, the applicable law was deemed enacted on the 2nd of December 1999 and provided that anyone born on the island of Ireland is entitled to be an Irish citizen and automatically an Irish citizen if he or she was not entitled to the citizenship of any other country. Historical provisions. The previous legislation was largely replaced by the 1999 changes, which were retroactive in effect before the 2nd of December 1999. The distinction between Irish citizenship and entitlement to Irish citizenship rested on the place of birth. Under this regime, any person born on the island of Ireland was automatically an Irish citizen if born on the island of Ireland before the 6th of December 1922, in the territory which currently comprises the Republic of Ireland, or in Northern Ireland on or after the 6th of December 1922 with a parent who was an Irish citizen at the time of birth, entitled to be an Irish citizen if born in Northern Ireland and not automatically an Irish citizen. The provisions of the 1956 Act were, in terms of citizenship by birth, retroactive and replaced the provisions of the previous legislation, the Irish Nationality and Citizenship Act 1935. Under that legislation, those born in Northern Ireland on or after the 6th of December 1922 did not have an entitlement to Irish citizenship by birth. Children of diplomats. Like most countries, Ireland does not normally grant citizenship to the children of diplomats. This does not apply, however, when a diplomat parents a child with an Irish citizen, a British citizen or a permanent resident. In 2001, Ireland enacted a measure which allowed the children of diplomats to register as Irish citizens if they chose to do so. However, this was repealed 3 years later. The option to register remains for those born to diplomats before 2005. By descent, a person is an Irish citizen by descent if, at the time of his or her birth, at least one of his or her parents was an Irish citizen. Place of birth is not a deciding factor. In cases where at least one parent was an Irish citizen born in the island of Ireland or an Irish citizen resident abroad in the public service, citizenship is automatic and dates from birth. In all other cases, citizenship is subject to registration in the Foreign Births Register. Due to legislative changes introduced in 1986, the Irish citizenship of those individuals requiring registration dates from registration and not from birth. For births registered on or after the 1st of January 1987, citizenship by registration had previously been backdated to birth. Anyone with an Irish citizen grandparent born in the island of Ireland is eligible for Irish citizenship. His or her parent would have automatically been an Irish citizen, and their own citizenship can be secured by registering themselves in the Foreign Births Register. In contrast, those wishing to claim citizenship through an Irish citizen great-grandparent would be unable to do so unless the parents were placed into the Foreign Births Register. The parents can transmit Irish citizenship to only those children born after they themselves were registered, and not to any children born before registration. Citizenship acquired through descent may be maintained indefinitely so long as each generation ensures its registration before the birth of the next. By adoption, all adoptions performed are recognized under Irish law confer Irish citizenship on the adopted child if at least one of the adopters was an Irish citizen at the time of the adoption. By marriage, from the 30th of November 2005, citizenship of the spouse of an Irish citizen must be acquired through the normal naturalization process. The residence requirement is reduced from 5 to 3 years in this case, and the spouse must intend to continue to reside in the island of Ireland. Previously, the law allowed for the spouses of most Irish citizens to acquire citizenship post-nuptially by registration without residence in the island of Ireland, or by naturalization. For the 17th of July 1956 to the 31st of December 1986, the wife of an Irish citizen could apply for postnuptial citizenship. A woman who applied for this before marriage would become an Irish citizen upon marriage. This was a retrospective provision which could be applied to marriages made before 1956. However, the citizenship granted was prospective only. Between the 1st of July 1986 and the 29th of November 2005, the spouse of an Irish citizen could obtain postnuptial citizenship after 3 years of subsisting marriage, provided the Irish spouse had held that status for at least 3 years. Like the provisions it replaced, the application of this regime was also retrospective. By civil partnership. As of the 2nd of August 2011, same-sex civil partners are treated in the same way as married individuals and may apply for naturalization after the same abridged period of residence of 3 years. The definition of civil partners include legal unions in other countries which offer similar legal rights and responsibilities, and accordingly the required year of cohabitation can have accrued before the Civil Partnership Act. By naturalization, the naturalization of a foreigner as an Irish citizen is a discretionary power held by the Irish Minister for Justice. Naturalization is granted on a number of criteria including good character, residence in the state and intention to continue residing in the state. In principle, the residence requirement is 3 years if married to or in a civil partnership with an Irish citizen, and 5 years otherwise. For the latter category, residence must be in the Republic of Ireland, while for the former, residence in Northern Ireland can also count. However, not all time spent in the Republic or in Northern Ireland will count for the purposes of naturalization. Time spent seeking asylum will not be counted, nor will time spent as an illegal immigrant. Time spent studying in the state by a national of a non-EEA state will not count. The Minister for Justice may waive the residency requirement for the children of naturalized citizens, recognized refugees, stateless children, those resident abroad in the service of the Irish state, and people of Irish descent or Irish associations. By grant of honorary citizenship. Section 12 of the Irish Nationality and Citizenship Act, 1956 allows the President, on advice of the government, to grant Irish citizenship as a token of honour to a person, or the child or her child of a person who, in the opinion of the government, has done signal honour or rendered distinguished service to the nation, although known as honorary Irish citizenship. This is in fact legally a full form of citizenship, with entitlement to an Irish passport and the other rights of Irish citizenship on the same basis as a naturalised Irish citizen. This has been awarded only a few times. The first 12 people to have had honorary Irish citizenship conferred on them are Alfred Chester Beatty, art collector, philanthropist and founder of the Chester Beatty Library; Tide Herrema, Dutch businessman kidnapped by the Provisional IRA; Tip O'Neill, Irish-American and Speaker of the United States House of Representatives; Alfred Bate, art collector and owner of Rusborough House; Jack Charlton, for his achievements as manager of the Republic of Ireland national football team; Jean Kennedy Smith, former United States ambassador to Ireland; Derek Hill, artist who established the Tory Island School of Painting; Don Keogh, former president of Coca-Cola. Plans were made to grant honorary Irish citizenship to U.S. President John F. Kennedy during his visit to Ireland in 1963, but this was abandoned owing to legal difficulties in granting citizenship to a foreign head of state. Loss of citizenship. By renunciation, an Irish citizen may renounce his or her citizenship if he or she is 18 years or older, ordinarily resident abroad, and is or is about to become a citizen of another country. Renunciation is done by lodging a declaration with the Minister for Justice. If the person is not already a citizen of another country, it is only effective when he or she becomes such. Irish citizenship cannot be lost by the operation of the law of another country, but foreign law may require a person to renounce Irish citizenship before acquiring foreign nationality. An Irish citizen born on the island of Ireland who renounces Irish citizenship remains entitled to be an Irish citizen and may resume it upon declaration. While not positively stated in the Act, the possibility of renouncing Irish citizenship is provided to allow Irish citizens to be naturalized as citizens of foreign countries whose laws do not allow for multiple citizenship. The Minister of Justice may revoke the citizenship of a naturalized citizen if he or she voluntarily acquires the citizenship of another country after naturalization, but there is no provision requiring them to renounce any citizenship they previously held. Similarly, there is no provision of Irish law requiring citizens to renounce their Irish citizenship before becoming citizens of other countries. By revocation of a certificate of naturalization, a certificate of naturalization may be revoked by the Minister for Justice. Once revoked, the person to whom the certificate applies ceases to be an Irish citizen. Revocation is not automatic and is a discretionary power of the minister. A certificate may be revoked if it was obtained by fraud or when the naturalized citizen to whom it applies resides outside the state for a period exceeding 7 years, otherwise than in the public service, without registering annually his or her intention to retain Irish citizenship. Voluntarily acquires the citizenship of another country, or has by any overt act shown himself to have failed in his duty of fidelity to the nation and loyalty to the state. A notice of the revocation of a certificate of naturalization must be published in Iris Oifajoyan in the period from January 2002 to April 2005. No such notices were published. Passports. Irish passports use the standard EU design, with a machine-readable identity page and 32, 48 to 64 visa pages. The identity page on older Irish passports was on the back cover of the booklet. Newly issued passports have been redesigned with additional security features. The identity page is now a plastic card attached between the front cover and the first visa page. The cover bears the harp, the national symbol of Ireland, along with the words European Union and Ireland in English and Irish. Visa-free travel. Visa requirements for Irish citizens are travel restrictions placed upon citizens of the Republic of Ireland by the authorities of other states. In 2016, Irish citizens had visa-free visa on arrival access to 172 countries and territories, jointly ranking the Irish passport 6th worldwide according to the Visa Restrictions Index. Citizenship of the European Union. Irish citizens are also citizens of the European Union and thus enjoy rights of free movement and have the right to vote in elections for the European Parliament.